Attorney General Hood is recognized for 5 minutes for his testimony.
Thank you, Mr. Chairman. I'm honored to be here today as representing the state of Mississippi as Attorney General. I'm here to tell you that there were 3 storms that have occurred as a result of Hurricane Katrina. One was Katrina itself. The other was the failure of the insurance industry to pay what it owed. And now we're facing incredible escalation in cost to reinsure to try to rebuild. This is a 3rd storm that we're presently facing. There's a great misconception out there that somehow we're trying to force insurance companies to pay for something that they didn't insure. And their public relations machine has done a wonderful job, including the Wall Street Journal, as the chairman mentioned. We're trying to make them pay for what they did insure. They were supposed to insure for wind. As one of my assistants pointed out, a saying that came up during the initial Clinton administration's campaign, it's the wind, stupid. They're not even paying for what they insured. And they used several methods by which they have accomplished that. Let me give you an example. People down on the coast, there were about 140-mile-per-hour winds. My home in Jackson, Mississippi, at the capital, is about 180 miles north of the coast. Blew the shingles off of my roof. State Farm was my insured. They didn't have the excuse not to pay in areas such as where I live. It blew shingles off the roof. I had my roof replaced. No problem. That's part of that 85% of those that they say that they have paid the claims on. They didn't have the excuse of the anti-concurrent cause provision that they have in their insurance policies, nor did they have the exclusionary provision. Now, where the dollars come involved are those people who were hit by storm surge, which is a relatively small strip along the coastal area of the state of Mississippi. For example, State Farm has 1/3 of the policies along our coastal area. They had approximately 9,000 homes that they had insured that were hit by storm surge. About 1,200 of those 9,000 wound up being just what we call slabs, nothing left. So those claims have not been settled, and when they use the term that they've been settled, that just means that they paid on them. That doesn't mean that the homeowner is satisfied with what percentage of payment that they may have given them. So the misconception that we're trying to rewrite an insurance policy. As Attorney General of the state of Mississippi, I filed a lawsuit within a couple of weeks because I saw where they were abusing their policy provisions, one being this anti-concurrent cause provision. What that provision provides, and let me point out to you that a very independent federal judge who's a senior status judge, been on the bench for years from my area of North Mississippi, had no ties to the coast, is the only federal judge on our coast handling these cases. Very learned judge, well respected by the Fifth Circuit. Judge Center in handling these cases struck the anti-concurrent cause provision. What that provision does is it says that, well, during the testimony of the case that he's mentioned about the punitive damages occurring, what the insurance companies did was they used satellite figures and determined where the storm surge reached. And they, in essence, said that we don't know exactly what took your house out, but we do know this from our studies that storm surge would have taken it out anyway. So during that trial, there wasn't a Mississippi jury that decided that part of the case as far as liability. The federal judge took it away from the jury and made a decision that the duty of an insurance company is to prove the percentage of the damage caused by the excluded peril, meaning the water exclusion. So they couldn't even prove what percentage of it was done by water through their own studies, much less what the wind did. So the federal judge directed a verdict and put a bad faith instruction before the jury, and that's where they came down with the punitive damages. And that's wherein lies the problem. people on the coast got hit with 140-mile-per-hour winds, you know it knocked shingles off their house at least. When it did 180 miles north at 100-mile-per-hour winds, yet when people filed a claim, they got zeroed. They got nothing, as Congressman Taylor pointed out, nothing. Federal judge with a $500,000 home gets a letter saying we owe you nothing. And that's because of the abuse of that anti-concurrent cause clause provision that the federal judge struck as being, in essence, is a bait and switch. You sell someone something and you take it all away because you know water will be part of a hurricane. So that was the reason that we filed that litigation, to get a quick answer. So it's not about the water. It's about the wind. It's about making them pay what they owe. How did they get around paying what they owed? They have established a program called ACE. That's a handling program adopted by State Farm. And what they did with this program is hide the double engineering reports that they had. One person even had 3 particular reports on one property, engineering reports, one saying water, 2 saying wind, and 1 saying wind and water, and another wind. So they hid these engineering reports and didn't disclose it to the people. They established this wind and water protocol September 13th of 2005, shortly after the storm, which requires that they this protocol, it's a letter that went out to all their claims people. It says that if water got in the way, in essence the anti-concurrent cause provision, then you make the federal flood program pay it all. We don't owe any. That's what happened to the taxpayers of America. They got dumped on by the insurance companies because their adjusters were out there saying that we're not going to pay for any of the wind because water was involved. And so they didn't even try to estimate a percentage that was done by wind that they owe. The federal flood program is owed money by the private insurance industry. I'll give you a quick example, and I'm not sure this shows stop, but I think I have 3 more minutes. I've argued.
You're over, but we're being generous with all the witnesses today, so we're not. I haven't gaveled you yet, so just wrap up as quickly as you feasibly can.
Finish briefly. In our remarks, we set forth some examples of people who had double engineering reports and weren't told. Those have been in the news media. I have to be careful about giving examples and none of this information came from our grand jury investigation, which is still ongoing as far as other companies are involved, and perhaps in this case, if the settlement doesn't go through, we may be dealing with that in the future. One last point I would like to make is how the industry, and this is why we need Congress to get involved, the industry threatens states, particularly one with 2.8 million people like the people of the state of Mississippi. State Farm, I reached a settlement with them. They indicated they were going to stay in Mississippi. That was the whole reason to reach a settlement. If I'd indicted them, they'd have left the state completely. Every agent's office shut down. 1/3 of our insurance market gone. I settled it to keep them there. But what did they do? They turned around later and left the state to threaten a federal judge, to intimidate our legislature, and to intimidate the justice system in Mississippi. And I suspect that that's what they will attempt to do here as well. They've done it in New Jersey and other states, threatened to leave, and I think their antitrust provisions need to be revoked and some regulatory authority placed over them at the federal level. Thank you for indulging me, and I'll try to answer any questions I can.